I believe I have it. Miss Rachel O'Barr and the firm of Anderson, Julian Hall, and you, the Industrial Commission. Corruption in local government agencies. Isn't it a fact that the Industrial Commission did 2 findings of facts and conclusions of law and order? One is the one that was based on May 2nd of 2012 in regard to the Industrial Commission's findings of facts and conclusions of law in regards to claimant's complaint that he filed on June 9th, because isn't it a fact that in the Industrial Commission's brief filed before the Supreme Court that they're really kind of arguing in regards to the Idaho Department of Correction records and Safe Corporation records? But isn't it a fact that the Commission also did 2 briefs for the Supreme Court? Because when I uncovered that there were actually 2 findings of facts and conclusions of law probably about 3 or 4 weeks after I received the findings of facts and conclusions of law, because me and my lady would happen to be reading the same document, but how could we be doing that when we're in 2 different folders of the Industrial Commission volumes? I was in volume 7, and then there's volume 8, which is the other findings of fact and conclusions of law. Because the first findings of facts and conclusions of law doesn't talk about Lynn Luker's lien. That one's in volume 7 of the agency's record. Now, the findings of facts and conclusions of law and order that the Commission felt no reason to disturb, that's in volume 8, has the reference of my lien in regards to Lynn Luker. Now, when I was sending things and requesting for the agency's records, Lynn Luker wasn't there at first, because I was just arguing with the Commission that I don't feel that Lynn Luker deserved a dime, because he did get over $4,000 and he's already been paid that. Now, I was already paid something by the Idaho State Insurance Fund, because before the Commission made their ruling on Lynn Luker's lien on July 10th, the state Serenity, or whatever it is, the state insurance fund, had already paid me some kind of a advancement or something, as they've tried to squeeze it into the payout, because it's worded as an advance, like in May 22nd or something. So supposedly that matter was already been in the process before July 10th of 2012, when the Industrial Commission ruled in favor of Lynn Luker on his attorney lien, even though I never received any documents that I requested from Lynn Luker during my request and my argument with the Industrial Commission. But now I'm wondering why Mr. Lynn Luker / legislator for the state of Idaho, I want to know why you're not responding to the appellant's appeal before the Idaho Supreme Court that was lodged against you, that is in reality really separate from from the state insurance fund. Because otherwise, why would the Industrial Commission have done 2 findings of facts and conclusions of law that are almost identical, as you tell the Supreme Court that I have filed these documents that are almost identical? Well, isn't that what you did, the Industrial Commission, in your findings of facts and conclusions of law? You filed 2 findings of facts and conclusions of law that are almost identical to each other, except one doesn't have anything in regards to Lynn Luker, as the other findings of fact does have Lynn Luker in it. Now, I was questioning myself, why would you do that? But then again, over time, I had to concentrate on something else. And then, for you to send me 2 briefs when you only needed to send me 1. So what you've done is you've sent me 2 briefs. So basically, 1 brief is in response to the Industrial Commission, of the State Insurance Fund, and the manner of my complaint, which is separate than my claim, because my claim number is different from my complaint number, which is 2008-01350, and my claim number is different. So since it's the complaint number that is before the Supreme Court, and the Industrial Commission in their writing is trying to put it all in a different, trying to head everyone off in a direction to take you away from the actual argument. The Idaho State Insurance Fund did not have permission and did not give me the opportunity to argue what is and what is not relevant. And Ms. O'Barr, as you said, HIPAA doesn't apply. Well, HIPAA does apply when it comes to protecting the private health records that you are entitled to. You were supposed to also, under the rule of the privacy rule, you were also to make sure that I was notified, and if there wasn't any objections, which we know there was, then I was supposed to have had that opportunity to argue what was and what was not relevant, and to make sure that you all went through your procedures to make sure that all these documents and everything are protected. Did the law firm of Henderson, Julian Hall, that was hired in regards to my complaint, because I was speaking with somebody else prior in regards to how the state insurance fund had received my records, how they sent me to work with, in the unlawful and deceitful way that they did. And then you all came into place and took over my complaint that I had filed. Now that I'm thinking about this too, is when I went to hire Lynn Luker, it was in relation to the complaint of how the Idaho State Insurance Fund had committed fraud and misdrew loans. On August 1st, 2008, received my private health records without a HIPAA release, didn't notify me prior to receiving those records, and sent to the other medical providers without protecting anything in it. Isn't it true also on August 7th, 2008? Again, Drew Loans violated a federal law. Did not inform me that she was going to take those private health records that she got in violation of a federal law and distribute them out in violation of a federal law to other medical providers on their behalf. And isn't there a 10-year rule also in there to where you're not supposed to be able to use anything 10 years and older? Well, you are. Isn't it a fact that that you're using records from 10 years ago that's beyond 10 years? And Mr. Hall, now that I've got it down in my deposition, isn't it true that I even stated I don't see the relevance of that? But you blew off and told me that you have a right to know everything about me? Well, Mr. Holt didn't. Mr. Wilson didn't. Because isn't it a fact that I've seen those guys prior to the hiring of Lynn Luker? Because I also have seen Mr. Wilson after the hiring of Lynn Luker in a panel view, which I know what a panel view is. It's something like, where you try to figure out if a person's going to make it through or whatever, and that's where you guys came up with, I was a poor historian, like I'm not supposed to remember things. But isn't it a fact? So where are we at here? Before the Idaho Supreme Court again. The Industrial Commission did 2 findings of facts and conclusions of law. They filed 2 briefs. So, Lynn Luker, why have you not responded to the appellant's brief that he filed before the Supreme Court? Or did I not file it properly and, oh, no, because it was a different one. I filed a different appeal before the Idaho Supreme Court because the State Insurance Fund one was already before the Supreme Court. Because the Industrial Commission decided to make Lynn Luker separate and awarded the State Insurance Fund their stuff and said, go ahead, do whatever, it's done, and I'll finish up with Lynn Luker over here on the side. And that's exactly what y'all did. Again, due to my ignorance, and I wasn't supposed to make it this far. I wasn't supposed to uncover that, was I? Every day I get up in the morning and put my feet on the ground, it's a new day. And yesterday morning, when I put my feet on the ground, it all came to me. 2 findings of facts, 2 briefs. Why isn't Lynn Luker, this last legislator of the state of Idaho, contacting this appellant in regards to my appeal of his ineffective assistance to counsel because he's a 3-time quitter? Do you know why none of these people are doing anything in regards to the way that I'm talking? It's because it's the truth. I'm speaking the truth. They can't sue me for anything because I'm not saying anything that's not the truth. Because Lynn Luker is a 3-time quitter. He quit on my Social Security disability in September and said that I don't owe him anything on it. But he tells me how, there's other ones out there that do workers' comp as a regular diet. And that I should send him some kind of a letter, but post-date it. So what were you trying to do? Get me to lie on a document? Mr. Lynn Luker? Mr. Luker, why aren't you responding? Are you hiding, Mr. Luker? Because is that what they're doing now? Is they're trying to protect you now that I figured it out? You are supposed to be before the Supreme Court. Why aren't you? That's why I may lose my freedom come June 5th, 2013. How am I supposed to get all this shit before the Supreme Court? And matter of fact, when Steve Kenyon, the clerk of the court, took those 2 medical documents and had them reviewed, he sent them to the Industrial Commission for review. And then next thing I know, my motion for stay of all proceedings was denied, and I had to file my brief. Even though I sent documents, well, that's because obviously the Industrial Commission is still making calls somewhere here. And I'm trying to figure out, and some of these documents from the clerk of the courts, they're not looking like letters that I usually receive from the clerk of the courts in regards to any of the filings that I've got to do. They're documents almost just like if they were responding, just like if the defendants were responding to me. Because it's saying respondent defendants or whatever, you know, where you know, James Clark versus, you know, the Idaho State Insurance Fund, blah, 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 blah. And then right under it, it always starts out as, you know, defendant, respondents. And then they kind of tell their story. Well, that's exactly how my last 2 things that I had to respond to look like. The only difference is the second page is saying ordered by this court, and then it has Chief Justice Burdick's name on it. It's not making sense to me. Again, I'm not supposed to have made it this far, but I have, because I'm a fighter and not a quitter. Because if you all get away with this, I don't have a life. I'm done. So, as you said, Miss Rachel O'Barr, and this is where it kind of started coming to me, because you were stating that every time I try to talk to you about certain things, you'd always come back at me and go, well, our argument is before the Supreme Court and in the records. But anything to do with the settlement or anything like that, you need to do it in writing and blah, blah, blah. And if you do it in writing, you gotta say that, you know, that the state insurance fund is entitled to overpayment of whatever settlement offer there is or whatever is going on. I don't know. Because now that I figured it out, there is two things going on. I have my claim, which, because that is not in the scoop, or that is not properly before the Supreme Court. Well, I'm not real sure. Again, what is before the Supreme Court? Because as the commission says, if these documents exist. Well, shit, man. I've been filing them to you guys for the last 7 months. What do you mean if they exist? Again, was I not to make it this far? Was I not supposed to have made it to oral argument before the Supreme Court? I'm still not really sure how I made it there myself. Because my understanding, there's only one other court that's higher than the Idaho Supreme Court. And isn't that the United States Supreme Court? And that's where I'll be headed next, I believe. Because again, I'm not a quitter. You will be held accountable. Because I think I just won't be talking for myself before the Idaho Supreme Court. I will be talking for everyone that has been taken advantage due to the corruption in our local government and local agencies. Local agencies. So, I will be speaking for all of us. People in government need to be held accountable for their actions. Because as long as there's lawless in America, there's going to be corruption. Because there is lawless in America. Due to the corruption. Look all around. Look at me. An injured worker who almost lost his life in his arm. Who can never longer do the work he's accustomed to make a living. But the Industrial Commission is trying to say otherwise. Or not really, because now that I put it together, what is before the Supreme Court and how it's worded in the brief is it is all about how they received my records from the Idaho Department of Correction. How they're saying that the state insurance fund has done no wrong. But again, Miss O'Barr and the firm of Anderson, Julian Hall. Miss Julone's violated a federal law. Federal Law 45, Part 165. And some other ones that are in there, in that category. Because again, it all comes down to yes, you can distribute private health records. But you still have to have permission. You still have to put safeguards in place. When you get private health records, that you have to send somebody to sign a HIPAA release for authorization for protected health records. But you see, now isn't it a fact that the state insurance fund did not even send me the HIPAA release forms for the Idaho Department of Correction, our SAFE Corporation, until sometime in September, when I started arguing. No, it was just right after October, because it was when I went to the doctors and I found out that they had gotten them. And in my second complaint, as you say, that I filed two almost identical complaints. Well, one complaint was, how is the state insurance fund able to get my health records without my authorization? The other complaint was, how were they able to get me back to work without seeing a doctor? And I wanted that $300 and something that I was entitled to for the week I was off. Well, to me, that complaint was completed. For number one, on July 25th, 2008, isn't it a fact that I uncovered how you all put me back to work without seeing a doctor? Isn't it a fact it was that job site evaluation that I went to Sandy Baskets, which is in her report, how Donnie Young contacted Sandy Basket and requested a copy of the job site evaluation with the approved signature on it. So, but isn't it a fact that my boss never seen the completed job site evaluation, but just a draft? So, I gotcha. The more I read, the more I'm putting it together. You guys are trying to scam me. You're trying to make me look like a fool. Well, wait till June 5th, 2013. We'll see who looks like a fool. Am I going to be as nervous as hell? Hell yes, I am. Do I got to learn to control my anger right now? Yes, I do. But I think knowing that I'll be coming in there and not just speaking for myself, but speaking for all who have been taken advantage of due to the corruption in our local government, in our local agencies, our local government agencies, like as the Industrial Commission, as the Idaho State Insurance Fund. But now where I'm a little confused is, am I before a federal court or a state court of appeal? I can't get nobody to really answer that to me, so, you know. But I know that I will go all the way to the United States Supreme Court. And again, you know, I would like to know why the Industrial Commission did not file my motion for an appeal, because I filed an appeal before the Idaho Supreme Court prior to the hiring of Lynn Luker also. But isn't it a fact that that's another area that you're trying to take everyone away from? That in fact, you did not file that. Because if I was to have filed an appeal before the Idaho Supreme Court prematurely, then at the conclusion, you were supposed to file that. But you didn't. But what you're doing is you're trying to talk about how it's an emotion. But what was that motion? You guys talk in circles, man. If I'm not allowed to tell the story, my spirit will tell the story. So, again, I'd like to bring it to an end. But again, I guess as you said, Miss O'Barr, that you guys have gone too far to settle. I don't know. But Steve Kenyon, clerk of the court, told me that, that you guys can still settle. It's not too late. You see, unless it's too late because you're before the Supreme Court. But again, you don't want to settle, so I'm bringing it all. Every stinking piece of paper that I have out in that garage is coming to you. The altering of documents, and how Carol Garland quit in the middle of August of 2008 after I found that job site evaluation. And then of course you guys did pay me that money, but you didn't pay it to me until August 22nd. Isn't that a fact? Or 21st, or, well, I know when my lady went to pick up the car from impound, there was 2 checks on the front seat, not just one. So, you know, but you're not telling them that in the writing. You're telling them in the writing that, yeah, in the writing. Isn't it all about in the writing how you're just, it's all about in the writing. Yeah. You're full of shit is what you guys are. And I'm putting my life on the line to stand up. Because I'm me. And the letter of my daughter, my kids, how they want to help me clear my name. Isn't it a fact that that's part of the private health information? And then you miss Jalone's. I mean, you miss Rachel Barr. You say it's in volume 1 of the agency's records. Where? Or is that one of the documents that disappeared like a fart in the wind? That's really not in the agency's records? Now, How come Miss Wilson / Arnold, because she was a Miss Wilson for a long time till about the last few filings, and then all of a sudden it popped up Arnold. So can you explain to me why she mysteriously was able to, my understanding, retire already? Again, when I catch somebody and I want them to be held accountable, because that was part of my motion for stay of all proceedings, because how am I going to be able to ask anybody questions if they're all getting retired in regards to their filings, or in regards to allowing these documents to go across her desk and to be sent to me knowing that they're altered? And then you, Miss Rachel O'Barr, in your affidavit of your personal knowledge, slander the firm. I'm going to sue you in a court. I'm not going to file nothing before the Idaho State Bar. Why? So it can all be swept under the rug again? No. I will be in town. We will be leaving here. We will be in town for the full day of June 4th. I will, on June 4th, be filing criminal charges against the law firm of Anderson, Julia, and Hall, and you, Miss O'Barr, for your false statements, your slanderous statements that hurts me in regards to trying to find work, about how I went and I went to force my employer to pay me more money. That's a lie. And we know about the other ones too, which those will come with me, because I have to have evidence that it was done, when it was done, and I have to be able to prove, because you're stating it wasn't done, that it was done prior to you all sending me any kind of medical release forms to fill out. Isn't it true that you keep referencing to August 15th medical records, but then you kind of squeak out about how later on, about in September filings, about how, and Mr. Clark is to sign these medical release forms that to investigate, to sign those medical release forms, and then later on to sign these other medical release forms, which included the Idaho Department of Correction and Safe Corporation. But now, isn't it a fact that in January and February, I went to Holy Rosary Hospital, and isn't it a fact that you had used the same document to receive my private health records? Because I got John's number, who is the director of records there. He's the one that helped me go ahead and clear that statement, which I have a copy that he sent to me, how it was changed and how this statement was taken out of my record, but it's still on the hard copy or something like that. I don't know. But, if you went to get my records, that statement wouldn't be there anymore. Which Lynn Luker told me, oh, don't worry about the Industrial Commission, I'll figure it out. Yeah, right. Just like you wrote to the commission, Mr. Lynn Luker, stating that if a hearing is set for, could you please set it for 10 days after legislation? So what did you do for that 7 months that you had my records that I gave to you? Mr. Lynn Luker, you're a fraud. You're a 3-time quitter on an injured worker, which I had to go and fight and get my Social Security on my own with the same identical records that the Industrial Commission reviewed. Same ones. They had them all.